Okay. Welcome to the 2019 edition of the TT&H Employment Law Seminar. I'm your host for today, Anthony Bowser. We're going to have an interesting program today, looking back over the past year or so since we last gathered, and I can assure you it's been a strange one. From the hashtag #MeToo movement and legislative efforts in response to that, to guys caught smoking weed on the job and then saying, "I'm just self-medicating, man. There's a law, don't you know?" Sorry, bro, you need a card for that, even though there's a law. First up today, you're going to hear from a panel of folks from our firm. We've got Dave Schwalm from our Harrisburg office, Meredith Wallach from our Baltimore office, and Chloe Gartside from our Philadelphia office. They're going to give you an update of interesting developments in employment law over the past year in Pennsylvania, Maryland, and New Jersey, respectively. So, without further ado, I'll turn it over to Dave Schwalm.
Okay, thank you. Do I need to use the mic, or are we okay with the table mic here?
Use the table mic.
I want to also thank you for showing up here this morning. I'm going to be talking a bit about developments in Pennsylvania employment law, and we're going to start out with talking about the PHRC guidance that was issued in August of last year relating to LGBTQ protections. You might ask why this is important, and part of the reason is that under Title VII of federal law, that specifically does not include protections based on sexual orientation. Some courts and some districts have held that.
Sorry, I'm not picking up in the back.
Okay.
There he is.
That's a little better. Can everyone hear me now? Okay. So in district courts throughout the country have had adopted different positions with respect to whether or not sexual orientation is protected under Title VII of federal law. And so in the Third Circuit, for example, the court there has held up until the present time that claims based upon sexual orientation are not protected by Title VII. So that's left it with the different states to try to adopt procedures of dealing with issues relating to sexual orientation. So the Pennsylvania Human Relations Commission in August of last year adopted these guidances clarifying what its position would be with respect to claims that are filed with the PHRC relating to sexual orientation. Now it's interesting when they present these guidances, they say, we're not making law, we're just telling you how we're going to adopt it, and the courts may decide later that what we're saying isn't legal or not. So it's that in that respect, it's kind of interesting the way they approach it. But what they do say is if someone files a sexual orientation claim, complaint with the PHRC, we're going to consider it and we're going to handle it like we would any other claim based upon race, sex, disability, all of the things that are specified by statute that deal with discrimination before the PHRC. Now, as you can see, when it talks about the different protections based on sexual orientation, it's fairly broad in terms of dealing with the basis of sex assigned at birth, sexual orientation, transgender identity, gender transition, gender identity, gender expression. Just very recently, the United States District Court for the Eastern District of Pennsylvania ruled that discrimination based on sexual orientation is not unlawful under Title VII of the federal laws. And this is what I was talking about, federal courts concluding that Title VII doesn't extend that far. That was the case of Guest versus Philadelphia Housing Authority. And that involved a hostile work environment based on a perceived sexual orientation. Again, the facts of a lot of these cases are interesting, and you wonder whether or not the court is basing its decisions on the facts before it in each particular case. In that case, the individual who was filing the claim had claimed that although he was not a homosexual, people that at his work perceived him as homosexual, and because of that perceived orientation, they had discriminated against him and created a hostile work environment there. In a case that I had handled several years ago, it wasn't an employment case, but it did involve a transgender case with an individual who had undergone sex change surgery to go from a man to a woman. He had been incarcerated in prison and in fact had been put in the female cell block and also put in the female hospital block when he had some health, or she had some health issues. But she was filed a claim against the prison based upon discrimination about her treatment while she was in the prison. One of the claims that we had filed in that case was that it should be dismissed because there's no protection based on sexual orientation. And the court there had decided we're not going to address that issue, but it did find that the prison hadn't discriminated against the individual based upon his transgender status. If you read through the definitions of each of these areas, it's really very broad, and you can include anything in how they define sexual orientation, and there's even an umbrella definition under the gender expression. One of the main things in terms of defenses that's available, though, is it talks about, the PHRC guidance talks about the Religious Freedom Protection Act, which is a Pennsylvania law, basically says that you can't force someone to violate their true religious beliefs in terms of dealing with these kind of discrimination issues. But in addressing an employer's rights to protection under the Religious Freedom Protection Act, it goes through a very long process of getting the courts to recognize what the religious freedom might be, including requiring them to file an action in the Pennsylvania Commonwealth Court to get to, and then there's timelines and deadlines to do that, and if the employer doesn't do it within a certain amount of time, the Religious Freedom Protection Act won't apply. So that's something. There aren't any cases that dealing with that issue out there now. The PHRC they're going through that process at the present time, and we'll see whether or not courts are going to adopt the PHRC's guidance in the future. Next area I want to talk about is the Pennsylvania Medical Marijuana Act update. And when we had our last employment law session here, we had a complete session entitled "Dazed and Confused About the Impact of Pennsylvania's Medical Marijuana Act on Employees." And I just want to say, with respect to that, again, there have not been any cases that have dealt with the employee protections that are available under that act. the provision that you see talks about employers can't retaliate against an employee based solely on the basis of their status as an individual who is certified to use medical marijuana. So as you'll recall, under that act, an individual who's prescribed medication by their physician needs to get a certification that they can take medical marijuana for whatever health condition that they have. And if they are certified, the law provides that the employer can't retaliate against them because of that certification. Now there's some interesting, one of the interesting things about that is whether or not someone can use medical marijuana while they're on the job site, and whether they can be exposed to certain requirements in terms of jobs, because some jobs prohibit you from being under the influence of drugs while you're at work. So that's one of the interesting aspects about the case. Now, as I said, no Pennsylvania courts have specifically dealt with the issue of this retaliation provision at that time, but there has been the case in January of Perota versus Pico, in which I think Anthony talked about it. In that case, the employee was self-medicating with using marijuana. He was an individual who had a foot condition and for which he had required surgery on his foot, and so he's self-prescribed marijuana usage to deal with the pain following his foot surgery. He was a senior engineer at Pico, and one of the conditions of their work was that they can't test positive for marijuana. Well, when he came back from his surgery after he had been off for several months, he was tested and it was discovered he had been using marijuana. At that point, Pico put him into the employee assistance program, and he was in that for several months, and he was off work with pay during that period of time. But after he completed the employee assistance program, the employer terminated him because he had been tested positive for marijuana. The court in that case, and we weren't dealing with the Pennsylvania law, they were dealing with claims under the Americans with Disability Act and under FMLA, and they were claiming retaliation under those federal laws. The court ultimately held that this wasn't discrimination based on his certification because he was never certified under the Pennsylvania law, and that as a person who was self-prescribing his use of marijuana, he wasn't protected from retaliation by the employer when he had violated that law. Now there's another case out of the district court in Connecticut where they have a similar state statute to the Pennsylvania medical marijuana statute. And in that case, an individual had applied for employment with a company that had a federal contract, and the company refused to hire that person because of the fact that he was, or I think it was a woman in that case, she was certified to use medical marijuana. The court there held that the case could go forward with the fact that she was certified to use marijuana, even though this company had a federal contract, and again, under federal law, marijuana is still an illegal substance. So that creates issues in those states where marijuana isn't illegal under the state law or is just misdemeanor or summary offense. But the court there specifically held that it doesn't make sense to say that this individual who's certified to use marijuana, if they test positive on the job site because they're using medical marijuana, that you would still be allowed to fire them because they test positive. So in that case, again, the court allowed the claims to go forward under a similar statute to the one that's in Pennsylvania, so that there's a couple slides there that talk about the individual's right of action and the fact that specifically under the federal the Drug-Free Workplace Act, that doesn't require drug testing for people who are using drugs outside of the workplace. Moving on to another recent case that came out of the Pennsylvania Superior Court, and this isn't necessarily directly relating to employment discrimination, but it's Pittsburgh Logistics versus BMAC. Again, this is just a very recent decision that involved an issue of a no poaching provision in a contract between two companies. And the no poaching provisions provided that the one company couldn't poach employees from another company. So you dealt with one company, it was a logistics company. The other company they had contracted with was a trucking company, and the logistics company basically facilitated contracts between the trucking company which shipped products and other third-party companies which had products to be shipped. Pittsburgh Logistics, obviously, because they had employees who would get involved between in the process of facilitating these shipments, they wanted to protect those employees from other companies hiring them, because then that would make Pittsburgh Logistics Systems services obsolete. And in fact, BMAC ended up hiring 4 of the Pittsburgh Logistics employees who had done work on the BMAC contracts. The Pennsylvania Superior Court held that these no poaching provisions are against public policy, and since it doesn't allow employees who aren't part of the contract to apply for jobs to other provisions, so to other employers. The Dittman versus UPMC case, it came out near the end of last year. It involves a economic loss doctrine, and I pointed out because it could be significant in terms of an employer's obligation to protect the private information of employees who give it to their employers as part of hiring, so that under Pennsylvania law, this case now recognizes there's a common law duty for an employer to protect data, and if the employer doesn't protect that data, the employee can sue for economic losses that the employer has as a result of that failure. And then finally, just bring up the fact that Philadelphia, in keeping with its practices of trying to pass ordinances that benefit employees, enacted the Fair Work Week Employment Ordinance, which won't take effect until January 1st of 2020. And I'm sure there's likely to be litigation over that, but that requires retail establishments, hospitality establishments, and food service establishments to give employees advance work notice of their work schedule, compensate them for changes in work schedules, rights to rest between work shifts, and offer of work to existing employees rather than hiring part-time or temporary employees. So that'll be an interesting case to see what happens, because obviously between now and next January, we're going to see some litigation over that. So with that, I'll turn the mic over to Chloe.
I don't know if it'll be easier for me to stand over there.
Do you want to switch places with me?
Either that or I can just.
Yeah, that's
that
fine.
microphone's on, correct?
I'm not sure.
I don't know.
I can click it for you.
Take this just in case.
Okay. Well, if you want to click it, I guess I can.
Click
That's
it?
fine. Yeah.
Here,
Okay.
I'll switch with you.
All right.
Musical chairs.
I'm fickle. Can you hear me my motor? Because I'm like.
What's your next?
No. Oh, yeah, you can hear that. You can leave that way. Good morning. My name is Chloe Gartside. I'm from the Philadelphia office. Prior to joining Thomas and Hafer, I worked at a plaintiff's firm doing employment law. So I know what it's like to be on the other side, and I thought it was a nightmare, and I'm thankful to be on the defense end of it. I am licensed in Pennsylvania, and the Eastern District Court of Pennsylvania, as well as New Jersey and the District Court of New Jersey. So I'm very familiar with New Jersey courts and the District Court. All right, so that is me in a nutshell. So where's the clicker? Oh, you have it. You do.
Yeah, you can
All right,
have
thank
it.
you. Hopefully, I won't turn it off. So the first thing I'm going to talk about is the New Jersey paid family leave. On February 19th, Governor Murphy signed into law a sweeping expansion into the state's family leave program. The plan had been enacted in 2008, and it expands that program to provide additional job protections for those who miss work due to caring for a newborn child or a sick loved one. And I should have also stated, New Jersey is trying to become the new hippie state. They're very, in many ways, they offer more protections than Pennsylvania. They have a longer time to file a claim in New Jersey. You've got 300 days. Pennsylvania, you only have 180. Unless you're in Philly, you have 300. The New Jersey paid family leave expansion. So it doubles the number of weeks for family leave insurance, FLI, and temporary disability insurance. It increases the paid family leave from 6 to 12 weeks, and leave has to be taken in consecutive weeks. The weekly benefit has also increased. Employees can now receive 85% of their weekly wage, with a maximum possible benefit going up to 70% of the statewide average weekly wage. So using data from this year, the maximum possible benefit will go up from $650 a week to $860 a week under the law. It also increases intermittent leave. Employees will now be able to take up to 56 days of intermittent leave within a 12-month period beginning in July 2020. And that's an increase from 42 days that they previously were able to take. There are anti-retaliation provisions in the Act. Employers with 30 or more employees are barred from retaliating or discriminating against an employee because they took family leave. And what's really different here, as opposed to PA, unless you're in Philly, you get protection. You can take leave for domestic and sexual violence. That's actually, that protection is sort of similar to, in Philadelphia, you've got the Philadelphia Commission of Human Relations, then the Philadelphia Fair Practices Ordinance Act, and that also protects individuals from domestic violence. So Philly's also trying to become, its own liberal little city. So back to New Jersey, the employee can take FLI if they were a victim of domestic or sexual violence, or to care for a family member who was such a victim. That, I believe, is a bit broader than that protection in Philly. Let's see. It also expands individuals eligible to take paid family leave to caring for siblings, in-laws, grandparents, grandchildren, other blood relatives, and any other individuals with equivalent of a family relationship. All right, now we're on to the fun topic of medical marijuana in New Jersey. We have the New Jersey Compassionate Use of Medical Marijuana Act. That was enacted in 2010 to decriminalize the use of medical marijuana in light of the legislators finding that, medical research has discovered a beneficial use of medical marijuana. However, recent case law has concluded that nothing in that act requires an employer to accommodate the medical use of marijuana in the workplace. Then with regard to off-duty medical marijuana use, there's a pending legislation bill which would protect one from adverse employment actions for medical marijuana patients unless the use impairs the employee's ability to perform job responsibilities. And I believe where that's really going to come in is when employers will drug test an employee. And then you have the issue, sort of like the foot issue Dave brought up with that Pennsylvania case. People testing positive, they might not be using it at work, but they might have used it, over the weekend to get rid of whatever alleged symptom they were trying to get rid of. Here's a recent case, Cotto v. Arte Glass Packing, Inc. There, the plaintiff argued that the employer violated PUMA and the New Jersey law against discrimination, the LAD, which is that state statute briefly mentioned in New Jersey, by refusing to accommodate his use of medical marijuana by waiving a drug test. So basically, this employee pointed to the act and said that the employer had to forego making him take a drug test because of this act. Well, the court thought otherwise. The act allows employers to accommodate employees who need medical marijuana, but it does not create a right of action for an employee to bring a cause of action against their employer. Actually, the court looked to a prior California decision with a similar statute, and in that particular case, the court held no state law could completely legalize marijuana for medical purposes because the drug remains illegal under federal law, even for medical users. Some other New Jersey medical marijuana decisions. We have Cobb versus Arte Glass, Inc. Again, in line with the previous case, defendants have no liability for failing to accommodate plaintiffs' marijuana usage. Barrett versus Robert Half Corp. This plaintiff had a medical marijuana card. He notified his employer of, his disability and showed them, presented them with his medical marijuana card. Then 7 months later, the employer conducted a mandatory drug test. The plaintiff failed and was fired. The court held that there was no cause of action to accommodate under the LAD, the New Jersey law against discrimination, because of disclosure to his employer that he was licensed to use medical marijuana as part of treatment for his disability did not render a request for assistance in connection with his disability. So he didn't say, I need to use it, for 1 hour a day. Just advising his employer of that right to use medical marijuana for a medical issue was not a request for an accommodation. Okay, now we have a new topic. This is interesting, the Diane B. Allen Equal Pay Act. This took effect on July 1st, 2018. It goes beyond requiring equal pay for men and women. It actually forbids pay differentials between any protected class performing substantially similar work. So if you're disabled, if you're a certain race, any protected class, They cannot discriminate against that. There's actually a recent case that just came out, I think like last month actually. So for the Equal Pay Act, you actually have 6 years to bring a cause of action, which is very different. But luckily, this case that came out last month, the law does not apply retroactively, which is important because the last paycheck that is issued is when the discrimination, the decision that when the decision took place to pay the employee a certain raise is the time, the date you go by for the statute, for statute of limitations purposes. But here, they said the act does not apply retroactively, so that's important. Defense is available if paid differently for the same work pursuant to seniority system, merit system, a system which measures earnings by quantity or quality of production, and certain bona fide factors. They must be job related and based on a legitimate business necessity. Basically, it is really important for employers to document the reasons why they're paying employees a certain rate. If they give them a raise, you really need to document as to why, especially given this, this 6 year statute of limitations. You really need to document everything. That way nobody can come back. They will come back. We're in a litigious world, but at least you have the documentation to prove that it was based on a legitimate reason. Remedies under the Allen Equal Pay Act, as I said, statute of limitations is 6 years and every paycheck restarts the statute. Treble damages are mandatory. Reasonable attorney's fees and costs for prevailing plaintiff is mandatory. All right, now I am going to turn it over to Meredith.
Thank you.
Do you want to?
I'll stay here.
Okay.
Hello, everyone. My name is Meredith Wallach. I am from the Baltimore office of TT&H, and I'm licensed to practice both in Maryland and the District of Columbia. I do employment law as well as workers' compensation law, so if you have any crossover questions, I can help. Maryland is an interesting jurisdiction. We currently have a Republican governor and a very liberal legislature. It's really an interesting time to be in Maryland, and the timing of this seminar is interesting for Maryland. We are right in the middle of our 90-day legislative session. So in terms of what is happening right now, I can tell you today they're voting on a minimum wage increase to $15 in the House, but will it pass? I don't know. It got out of committee, I think, 2 days ago, and they're voting today. So we shall see. I was looking on my phone to see when, but I don't remember. Today. There's also a ton of medical marijuana legislation on everybody's mind in Maryland, and that includes legislation that will impact employers. Excuse me. Senator, his name's Zirkin, is the chair of the Judiciary Committee, and he's putting forth quite a few. I think he's putting forth 11 of the 18 medical marijuana bills. I've heard him speak on the topic. It's very interesting. But so what I'm going to present to you about, primarily just because things are in flux in Maryland right now, is what happened last year, because laws that are not budget or tax related basically go into effect on October 1st. So these are the laws that went into effect on October 1 of 2018. Yes, it's up there. So Maryland passed the Disclosing Sexual Harassment in the Workplace Act of 2018 in its past legislative session. Oh, and I will say that all of the delegates and state senators in Maryland are working senators, so they have full-time jobs and then they leave, and go to Annapolis. That's where I actually live, so it's crazy there right now. They all come to Annapolis and then they go back to their regular jobs. So it's very political, very interesting. So they passed Maryland's Disclosing Sexual Harassment in the Workplace Act. It went into effect October 1st, and it has this goal of limiting an employer's ability to avoid sexual harassment claims and to keep those claims under wraps. So this is in direct response to the Me Too movement. The act renders null and void. Did it switch?
Yep.
Yes, it did. Thank you, Chloe.
No, that's Dave. I can't take credit
Thank
for
you,
that.
Dave. The act renders null and void as against Maryland public policy any provision in an employment contract, policy, or agreement that would limit or waive any substantive or procedural right or remedy somebody has for a claim of sexual harassment or for retaliation based on sexual harassment. And that's for instances that occur in the future. So if you're contracting against future claims. Now, contracting in that manner has its own problems already, so substantively, how much does this change everything? Up for debate. But it's important to know that that is on the books in Maryland now. The other part of this act is that there's a required reporting component for employers with 50 or more employees. And I'm going to get into more detail about that specifically, about the information that's disclosed, or that will be disclosed. So what the act doesn't define, and this is important, it doesn't define what is sexual harassment. And as we've been talking about, and as I'm sure hear in the news, there are varying degrees of what could that be. So you have to be aware of that. It also doesn't define who an employee is. It also doesn't speak to, if you're a business with multiple locations, if things are occurring out in another location that outside of Maryland, does that get reported? It's very vague. So there's a lot of room for interpretation. It's important to know that the Act imposes restrictions and waivers relating to future claims for sexual harassment and retaliation only. So if a claim has already accrued, you're not prohibited from entering into agreement regarding that claim. And it doesn't also invalidate past agreements made for sexual harassment or retaliation agreements. Importantly, there are penalties set forth in the statute, but it's not when an employer provides an employee with a contract or agreement which would be against public policy under the statute. It's only if they try to enforce that agreement. So that's another part of the act, and it's not super specific. The penalty is that they would be responsible for reasonable attorney's fees and costs in any action, but it's only linked to an employer attempting to enforce that agreement. There are other issues with the act, and importantly, something that it says is except as prohibited by federal law. What does that mean? And that's a big open question in Maryland. So thinking about things like arbitration, the Federal Arbitration Act, the FAA strongly favors enforcement of arbitration clauses. And an employment contract that contains a mandatory arbitration clause, if it's covered by the FAA could preempt the act. So that could have to go to arbitration even though the contract is technically not permitted under Maryland law. The FAA would prevail. If the FAA does not preempt, then that would mean an arbitration clause could be null and void under the act. And from a practical perspective, that presents a lot of issues. Arbitration agreements generally include wide-ranging, how should I say this, things that are race, sex, harassment, all in the same clause. So if there's a single incident that could involve race discrimination, sex discrimination,
gender discrimination, you could end up in different forums if the FAA does not apply. So some could be in arbitration and some could be back at the state level. So be aware of that. It's an open question and it's fairly complicated. The survey component is next, and this is what I really want employers to be aware of. Employers with 50 or more employees have to complete and submit an electronic survey to the Maryland Commission on Civil Rights by July 1 of 2020, and again by July 1 of 2022. And the information that it covers, the number of settlements made by or on behalf of the employer after an alleged sexual harassment of an employee. Again, who is an employee? Is it an independent contractor? I don't know. A number of times the employer has paid a settlement to resolve a sexual harassment allegation against the same employee over the past 10 years. The number of settlements made after an allegation of sexual harassment that included a mutual confidentiality provision. And then it also provides a space for the employer to provide its own information. They don't have to, but they can provide information on whether the employer took personnel action or disciplinary action against the employee who was the subject of the settlement, so the person that was the harasser. So you can provide that information if you would like. This is important. In filling out the survey, you have to be really careful, not only that you keep those numbers and develop a system to do so, but you also have to be aware that while the commission is going to take aggregate data and create a report, the actual individual survey responses are available via information request. So everything you put on that survey can be public. Something to keep in mind. So, moving what to do. Be sure you're collecting and retaining all that information that you need to complete the survey. Make a tracking system, however you want to do that, and just really be aware of how public that information can become in the survey. So I know we're running short on time, but other laws that took effect on October 1st, our state employers have to provide a place for moms to nurse or really pump at work at a place that is not a bathroom. Executive branch employees got 60 days of parental leave. State employees were required to complete sexual harassment training with enhanced requirements for managers. And jockeys coverage for workers' comp purposes got expanded. The other thing that happened that I didn't put on this slide is that with some exceptions, contractors are now jointly and severally liable for wages that their subcontractors failed to pay, which is fantastic. There are exceptions, but that's what's going on in Maryland, and I will let you know probably at the next one of these seminars or via e-notes of what happens in Maryland in the before, I think session ends on April 8th, so we'll see what they do. Thank you.
Does,
I want to move on to.
okay.
You can go.
Oh, go ahead.
Yeah,
go ahead.
Sorry, I wanted just to mention one thing. In Philadelphia, there's a hot issue. It's called a ban the box law, and a lot of employers get hit with it. If you go too far back, you can't ask certain questions about criminal background history. So if anyone ever has any questions about that, please feel free to contact me. I dealt with a lot of that at the plaintiff's firm I worked at prior to Thomas and Hafer. So.
With that, does anyone have any questions for any of us concerning any of these developments in law in any of those states?
Great. Okay, well, thank you, Dave, Chloe, and Meredith. We had planned to take a 10-minute break, but since we got a late start, we're going to cut that back to 5 so everybody can have a chance to freshen up your coffee, hit the restroom. Let's be back here in 5, and we'll talk about Me Too.
Me too.
except for getting started late.
That me not figuring out the what is standard setting.
Oh, no, that was
that's all
fine.